Hi, everyone. Thanks for joining us for our sixth session. And this one is going to be a little bit more detail orientated because, of course, it's a little bit more of a complicated topic on trusts and estate planning. So what we decided to do is kind of structure it around the who, what, when, where, and how, and what do I need to know? And thanks again, Matt Trotta from Field Law is joining us again today to discuss this great topic. So thanks again, Matt, for being here. We really appreciate your involvement.
Hey, thanks for having me.
Great. So, I guess the first thing is everyone asks is, when do I use a trust? So when you use a trust is basically you can have a trust when you're alive, which is called an inter vivos trust, where you transfer property to hold in a trust while you're alive. Or you can also do a trust when you have passed away, and then it's created upon your death called a testamentary trust. There's a trust, of course, that you can do for business owners. There's trusts that really are created if you, let's say, want to take care of a spouse and you have family from other marriages, or let's say you just want to take care of your spouse because you maybe have a difficult family and you want to make sure that your wife is looked after, and then you can then provide for your family. There's also the other consideration in all of this is, of course, taxes. So we'll talk about that a little bit later in the session, but of course, a trust is always taxed as an individual. So that's something to always consider. A lot of people think it's a business and it's a separate entity, and it really is not. Okay. The next one is trust.
Sorry, I'm just
That's okay.
frozen screen here. There we go.
Oh, perfect. Nope, go back one. Oh, we have to go back one, Jeff. There we go.
Sorry about that.
The what and who. So a trust, basically the relationship is where one person, settler, it's called the settler in this situation, gives property to another person. So that's a trustee, and they hold it in benefit for somebody else, which is what's called the beneficiary. So the trustee actually makes sure that the beneficiary is looked after in this, and the person who settles all the stuff then has no more involvement in it usually. So a trust to exist, you have to have certainty of intention to create the trust, which means there has to be clear intention on the part of the settler to create the trust. There has to be certainty of subject matter, which of course means that your trust property must be clearly identified and that the interests of the beneficiaries must be certain. So you know what you're doing around that. And certainty of objects means the beneficiaries of the trust must be ascertainable. And Matt, you can talk about that a little bit more in detail.
Absolutely. So we call these the three certainties because they determine the ability of a trust to truly exist. There's a fourth one that is often grouped in with the three certainties, which is validity of constitution. So what this means is, did the trust actually receive the gift? Did it receive it? Was it actually validly constituted? So in a lot of cases, somebody may set up a trust and not change the bank accounts, not provide the gold coin or other settlement property. So that comes up quite a bit. Important thing to realize is a trust is not a legal person or entity like a corporation is or like an individual is. A trust is a legal relationship between persons. So it's a relationship between the settler who provides the gift to the trustee upon certain terms for the benefit of the beneficiary.
Okay, go on to the next one. And the why.
And so from there, the question becomes, so that's what a trust is, but why are they useful? So historically, they used to be a lot more useful, which is why we say why still trusts. So historically, they had a lot more favorable tax treatment than they do now. There was a lot more room for income splitting. So of course, that was taken away in the last few years. But they're still quite useful, and we'll kind of go over the primary reasons why they're still very beneficial to use in a planning context. The first one, the biggest one, is asset protection. And this is important because while a trust is not a separate legal entity, it is a separate legal relationship, and it is respected on that term. So if you give a property, if you settle on a trust, for example, you as a settler no longer own that property. You have now given it to the trustees to hold and benefit for a beneficiary. So that is helpful for when we're dealing with creditors. But of course, if you have creditor issues, you can't just go settle a bunch of trusts and put money in, because that would be what we consider to be a fraudulent preference. This is handy where there may be future potential for unknown creditors to emerge. So for example, if somebody is single and they set up a trust for a potential marriage that potentially goes sideways, that would be an example of creditor protection that's useful. It may be putting growth shares in a company, in a trust, and those shares would be separate from the person who may have creditor issues down the line. Another big asset protection reason is privacy, or to be able to keep assets separately known, because a big thing with estate administration is when we use wills and they require probate, that is a public process. So you have to report to the court all of your assets and liabilities, and that can be retrieved. Somebody can pull the procedure card and the documents that have been filed at court, and they can see that. That can be a big problem for people, especially for certain people who want to keep some of their assets hidden from their family that they don't hold a legal or moral obligation to. So a trust is a private document. It does not have the same sort of disclosure requirements, not to say it can never be disclosed, but it has much more privacy and much more control. Another important aspect is when you settle a trust, it operates on its terms, subject to a court making an order, but even then, the ability of a court to make an order to direct a trust to do something pales in comparison to what it can do for an individual or what the powers are under estate law. So I previously mentioned moral or legal obligations, and that's a type of notation in statute, and that's very important to note, is you have situations where the statute require you to do certain things, require you to provide notice, to provide certain amounts. Trusts don't do that. And I mean, BC, for example, have extended that to adult children, even though they may not be dependent or disabled, but they have a right to certain things. Well, under a trust, they wouldn't. So there's a lot of benefits there. And that kind of leads into family law claims as well. If you have a trust that was set up before marriage or was set up with independent legal advice, and this other spouse was aware and participated and got that independent legal advice, it may hold up a lot stronger on a dissolution than it would if you didn't have a trust. That being said, a trust is not 100% unassailable. And I think that's important to note, as a lot of people think that they have money in a trust, or they set up a testamentary trust for their children, that the income and capital are safe. Well, the capital is safe to a point, but the growth on it may not be, and the income from it certainly is not necessarily, if it's going into the same person, it's a predictable stream. But there is a lot more of a defensive ability if you have a trust, preferably an inter vivos versus a testamentary for that privacy reason, but there is that ability. As mentioned, there's statutory requirements, and that's where trusts have a great advantage on dependence relief and wills challenges, because it operates in a different way. Now, that's not to say that you can shirk your responsibilities on dependents, but because a trust is a separate legal relationship, it does have some defensive measures. Trusts are also very useful for providing for special needs or disabled beneficiaries, because they will be able to monitor and be able to adapt to changes in legislation. Good example would be AISH in Alberta. A trust is considered an exempt asset, so you can set up a trust in life. They're sometimes known as Henson trusts for disabled beneficiaries that wouldn't count against their income or capital totals until they receive the income or receive the capital. And so that can be very useful there. Also, trusts are very useful for where you have beneficiaries. We call them irresponsible beneficiaries, and that can be a lot of different things. That can be somebody who we call a spendthrift who has financial issues. This could be somebody with substance abuse issues. And this allows the trust to provide to or for the benefit of that person. And that's very important key, because that means they may get the benefit of that money, but they don't necessarily get a check that they can make out to cash. This could be used to help fund programs, fund housing, and it can provide the trustee with the instructions that they need to be able to properly administer for this person when you're no longer able. They're great will alternatives in a lot of cases, especially for older clients. When you're over the age of 65, it's very common to put property into alter ego trusts, which are settled by you for your benefit during your life. Hence, the trust is your alter ego. Or a joint partner or joint spousal trust, which similar principle, it's settled for the benefit of both spouses until the death of the second to die spouse. Now, there's still that deemed disposition at death, as you would as an individual, but a trust can then continue on, have its end beneficiaries, and completely bypass probate. This is especially useful in places like BC and Ontario and the Maritimes, where there's probate taxes. This is also useful for land transfer tax because the property may stay in the trust. So there may be fewer instances of a change that would necessitate a land transfer fee. But you have to be careful in each province. They may have different rules on what constitutes a change of control and whether or not that trustee change is something that constitutes a fee. Your mileage may vary there. Trusts are very effective to be a voting shareholder in privately held corporations. This often will come as a result of an estate freeze, which I'll talk about a little later on in the presentation. But this is handy where you want to leave the benefit of the growth of the company to your children, but you don't necessarily want them being the shareholder of these corporations. And you want to have either a layer of a professional or you yourself wish to be the voting shareholder without holding the beneficial interest behind those shares. And that can be very useful there. Incapacity planning is also very helpful. This comes up in a lot of cases where somebody currently has the ability to manage their affairs, but they know in time that they may not be able to. So this allows them to introduce a trustee to manage their funds, perhaps with them, in a co-trustee relationship. And then as they become older and no longer wish to or no longer able to, it allows them to phase out to kind of get their succession planning going in a way that isn't as shocking to the system, because it's sort of been a development over time. And then from there, the trust is set up to take care of them, to work with an attorney or agent under a power of attorney or personal directive to make sure funds are available. And then that trust would be able to gift to the end beneficiaries upon passing of the person who set up the trust. As mentioned, they're very flexible. Trusts are set up typically to be discretionary. There are fixed trusts as well, where the beneficiaries are fixed and the interest is fixed in which they can receive it. Sometimes we do that for tax purposes, but generally they're very discretionary. They can be varied. So it allows for a deferral of decision making in the future. If we're not sure who we want to gift to, we can gift to a class or have a class described. We also want to be a bit careful here, though, not to be too flexible, because CRA likes to get their tendrils into trusts a little bit, and we want to avoid a deemed resettlement, which can trigger a tax event as well. These last two here, we're going to go into bigger detail on the potential tax benefits, as well as going into where a trust coincides with property ownership.
Yep. So the how. So what happens in a trust is a lot of people say, well, how do I have control of this trust? What am I doing with this trust? And I think the key around this is that you have to name a trustee, obviously, that you think is responsible, that will manage this trust, handle the trust, settle the trust, do the taxes for the trust, because there's, of course, taxes every year. The trust then names a beneficiary or more beneficiaries. There may be more than one. Identifies the assets that are going to be managed inside that trust and will manage them. Set out the terms and conditions, including investment powers. So sometimes people say, I don't want you taking too much risk with these assets, or it might be a property where they say, there has to be some terms and conditions around how this property operates and what it does. So who gets what when, when we talk about capital and income that Matt had mentioned earlier, is sometimes people say, you know what, I want them to have the income of this trust, but I don't want them to have the actual capital till a bit later on in life, or, they're only an income beneficiary and they can get the income from the trust, but the capital then might go on to somebody else. Those type of things happen as well in spousal trusts where someone might be remarried and they say, you know what, the house has always been, the old house of the family, and we want that house to go to the children. We don't want the house to then go to that spouse, but the spouse can use it indefinitely until, something happens that they get remarried or they do something to the kids, or, something to that matter, where you can kind of say, I've got some rules around how you're going to operate, but you can use the house in the meantime until that happens. And so that's something that would be really great. And then, of course, you can set them up to take effect during your lifetime. So again, it can either be while you're alive, or it can be set up again when you're passed away, and then you set up a trustee to actually manage those assets. Okay.
So potential tax benefits of trusts. As mentioned, estate freezes are a big one. It's something that's been long-standing in tax planning, and fingers crossed, not something that's in the crosshairs of the federal government right now. And what an estate freeze is it's a tax-deferred reorganization where shares are exchanged for new fixed value shares. Often they're preferred shares, and they're often referred to as well as free shares. And by doing this, we've now crystallized the value of a company. So say a company was valued at $1 million and you had 100 Class A common shares. We now would exchange those common shares for 1 million preferred shares redeemable at $1 each. Now the remaining value of the corporation is zero. So we can now subscribe for new shares, new Class A common shares for a nominal amount, $1 a share. What this does is now the value is secured in these preferred shares, and they can retain control of their business. Often these preferred shares are voting, or part of the reorganization would include what we call skinny shares, which are voting shares that don't have participation and don't grow. But now the future share growth is in the hands of these common shares, which can benefit from that growth. It's used for succession planning. So often this is a way for children to buy into a business, is by buying in on the future growth. And this is where a trust can be very handy, because the trust can now hold these shares and then in theory distribute those shares out over time or continue to hold them long term.
Yeah. And we've had some good cases, Matt, that we've worked on in the last few years that, even one in particular that I always thought was interesting is, Dad owned an oil company and a couple engineering firms, wanted his son to eventually take it over. And, his son was in music and, had a band and did that kind of stuff, had no experience whatsoever. And so a lot of this experience was like, okay, he didn't want the business to go to his wife. He wanted the business to go to the kids, and whether someone else managed it or whatever. That's when we came up with, this really can be used even when you have uncertainty in a succession plan, where he had millions of dollars built up in this company. And it was like, from a tax perspective, he would have been really not been able to utilize his capital gains exemption if this continued to build like it was, and it was building quite extreme. And the son, when the dad passed away, the son did get the business. Actually, the two sons got the business. One turned out to be an accountant, and the other one turned out to actually go to school, learn how to operate this business, and did that. But the business was still able to run this way with other people, and there was great insurance built into this policy and into the whole structure. And so they were able to actually have business money to run. They had business money to buy out the tax, pay out mom, and deal with all the structure of it, because it was just so easy to be able to do that. It gave him the opportunity to learn, and he did want to be part of the business, which is essentially what Dad's always wanted to do. And I think we've seen that so successfully with so many businesses now be able to capture that. And I think, that tends to be a great thing to do and think about early on as you make money, for sure.
Well, and that's exactly it. And that's where that flexibility comes in. Like, as in that case, there's, a bit of uncertainty on who would end up holding it at the end of the day. And that's where a trust can come in handy, where, there may be a combination of cash and shares. It may be able to gift to the child that wants to take over the business and provide cash to the one that doesn't, or hypothetically, and I've worked on a few where we're doing this, the trust kind of sits and equalizes from an estate distribution, and the trustee takes their cues from how to administer the trust fund based on what the estate distributes out to the beneficiaries, who are typically the same persons. So there's a lot of different flexibility that can come with that. And one of the nice things about that is estates typically have to go through probate, and there's a bit of a delay, where a trust doesn't. And so that's handy both in the business standpoint, because we know who the shareholder is the day after somebody passes away, and then that shareholder can appoint a new director that afternoon. And there's no issue of continuity, especially if you have a situation with a business with multiple employees, but only one director and one shareholder, which happens more often than it should. But there's flexibility with the trust. The other real nice benefit of tax benefit in estate planning is the ability to income split. So income splitting has gone through a bit of an assault in the last few years, and has been given, it's been demonized quite a bit to make it sound like any doctor and their spouse are tax cheats who are engaging in acts. And historically, that hasn't been the case, and wasn't the case, and still isn't the case. But what a trust is allowed to do is, because a trust is a separate taxpayer, we now have the ability to have it taxed in the trust. So a trust is taxed at the highest rate, which we'll go into a bit more details in a bit about the tax ins and outs of a trust. But sometimes that highest marginal rate is lower than the rate of the beneficiary or of a member of a settler, for example. So it may make sense to have that. It also distributes its income, and that income isn't taxed in the hands of the trust, it's then taxed in the hands of the beneficiaries. So we can distribute income in a way to have it taxed in the hands of that individual person. Now, what we do need to be careful of now is attribution rules and TOSI rules. So with attribution, a good rule of thumb is, if it's gifted by the settler and can revert to the settler, it's going to be taxed in the hands of the settler. And that goes by extension to if it comes from the labor of that person. So for example, private corporate or professional corporations rather, there may be some TOSI on that. One of the ways around that may be the trust getting money by means of a loan at prescribed rates. Now it has to be sufficient enough to justify the payment of interest every year, but there are ways for a trust to do that, and to do it in a way that is tax advantageous and financially expedient. But it's still an option even after the assault. Probate fees aren't really an issue for trusts, so that's why they're beneficial. And we call it a tax benefit here because, as much as BC government and Ontario governments and others recoil at the idea of calling it a tax, it's a tax. And so having a trust and having assets within a trust reduces the ability for them to tax on death. There's the ability to defer tax on capital gains within a trust. And how that essentially works is, a trust acquires shares or investments, and when it distributes to an eligible Canadian resident beneficiary, the beneficiary receives it at the same adjusted cost base as the trust. So we defer any gains until that beneficiary disposes of the property. And at that point in time, they may have offsetting capital losses, or they may have a lower tax rate at that time. As mentioned, trusts are often taxed at a lower tax rate than the beneficiaries. Historically, this was magnificent planning in Alberta, because we had a highest rate of 39%, and in the East, they had their highest rates well over 50. So there was a really nice tax arb. And so you'd have trusts where the mind and management was located in Alberta, the assets were in Alberta, and the beneficiaries were in that other province. CRA got quite aggressive on that, and there's a lot of modern case law and trust residency, and we have to be careful about that. And even though we went from 39 to 48, and who knows where it'll go in the future, there's still a benefit there. And we're starting to drop down incrementally, but we'll see what happens in the future. But there's still a bit of a tax arb compared to Ontario, Quebec, and the Maritimes. Trusts are also very useful to reduce or avoid U.S. estate taxes for U.S. beneficiaries because it will reduce the value of their worldwide estate. This is one that can come in handy a lot, but again, when we're dealing with trust cross-border, we have to be mindful of the residency of the trust and the compliance requirements for the beneficiaries. As mentioned, qualified disability trusts, which are testamentary in nature, can be set up to avoid AISH, but Henson trusts can also be useful inter vivos to be exempt from AISH as well. And then as well, we have this ability for a rollover to be available when property is distributed or to a qualified trust, such as a spousal or life interest trust. So how do trusts get taxed in Canada? Well, effectively, as Pam mentioned earlier, they're considered individuals, but they don't get the same personal credits available to individuals, and they're taxed at the highest rate. There's two exceptions to that. One is a graduated rate estate, and the other is a qualified disability trust. Graduated rate estate is effectively the primary or the estate of a person who passes away, provided that all the assets of the trust of the estate have been received on or as a consequence of death. And that can get a little bit funny if we have a situation where an estate receives as a beneficiary from an inter vivos trust. We could run into problems, especially if a trust is set up to hold insurance proceeds and then the trustee proceeds to give it to the estate after. We run into problems there. Graduated rate estates are taxed like an individual for a 36-month period. They are entitled to use different provisions of the Tax Act to their benefit, including charitable beneficiaries, flexibility, loss carrybacks, and just general flexibility that historically were available to regular testamentary trusts, but aren't available post January 2016. Important thing to note here is only an estate can be a graduated rate estate and not a testamentary trust that arises out of a will. It's a distinction that gives a lot of practitioners cross eyes, but it does occur and it can be a bit problematic. The other is a qualified disability trust, which arises where you have a beneficiary of a testamentary trust who is a person who's qualified for the disability tax credit. They jointly elect, and they're the only beneficiary of that trust. Important distinction is under the Tax Act. This is where it gets a little cross-eyed for professionals. Estates and any testamentary trust arising from that estate are each considered to be a trust under the Tax Act, except, of course, a testamentary trust can't be a GRE, only an estate can, even though an estate is also a testamentary trust. Yes, that's right.
Yep.
How we determine the residency of a trust is determined where the central management and control of the trust actually takes place. And this can dramatically affect its rate of taxation. It can also potentially affect the rules in which it's governed by. This one comes up an awful lot, and this is one where people have to be careful because we often will run into situations where people hire a professional trustee to act because they're in a better jurisdiction. So Alberta was great for this, where you'd have somebody who was in Ontario, they hired an Alberta lawyer to be their trustee, and so they claimed that the residency of the trust was in Alberta. Sounds great, except when that person doesn't let go of their control, when they're directing the trustee on how they're supposed to exercise their discretion, where is the mind and management? Is it downtown Calgary at that lawyer's office, or is it in the Muskoka where the client is sending instructions? CRA says it's in Muskoka and we lose the benefit. So we have to be careful when we're dealing with trusts that we're balancing out this residency issue. So when a settlor or grantor in the US transfers property to a trust, it's done by means of a gift, either a gift in life or a gift as a consequence of death. Gift is generally a disposition under tax law, which means it can be taxable. On death, you have your deemed disposition. In life, it would be a disposition of assets, and there may be capital gains payable. That being said, there are certain transfers that qualify for rollover treatment. So if you gift to a qualifying spousal trust, alter egos, or joint partner, joint spouses. From there, income is taxed in the hands of the trust, unless the income is flowed through to a beneficiary. when it flows through, and this is very important, it has to be paid or payable within the year. And this can be a real pain from an accounting point of view, because you don't necessarily know what the income of the trust is until you're doing your return. And your return is filed 90 days after the year end. So we have to be very careful about that. And it's important to make, if you make distributions in the year, that they're very clearly evidenced to be paid or payable within the year. Otherwise, it's considered that it was paid in the next year, even though it was intended to be paid in that current year. Generally, trusts can distribute on a rollover basis to Canadian resident beneficiaries. This is called a 107(2) transfer. And this, how it works is, how, as I mentioned earlier, where it's you get at the ACB of the trust. Important thing to note here is this does not apply to foreign beneficiaries, and there are a few ways for you to get trapped on this one. The other thing I'll mention here is trusts, with exceptions of a few here and there, such as alter egos and joint partners, are deemed to dispose of and reacquire all their capital property at fair market value every 21 years. So this is where you get that misconception that a trust can only last 21 years. A trust can last a very long time in Canada, but it's going to be taxed every 21 years. So what we do to get around that depends on the trust. We may take tax hit if it's advantageous to do so. There may be offsetting losses. We may distribute everything in a gain position to beneficiaries to defer that capital gain to a later date, or to be able to access their losses. But it's something to bear in mind. And so from here, we'll move on to the next one, unless there's any questions so far.
Okay, yeah, there looks like there's no questions, but please, everybody, you know, if you have some questions, we know this is a bit complicated. We know a lot of people on the call have BC properties. We also know quite a few people on the call have US properties. So, you know, ask away, because I think there's some value if you have some questions in regards to those properties and your personal situation. It's probably pretty valuable to even explain to the whole audience, because everyone's going to get a piece of value out of this, because it really applies to everybody. It's not just a case by case specific situation. So, you know, if you have questions that are in regards to your own personal situation, please ask those, and you can just put them in the chat. And we'll answer them too as we go, because I think this is important, and especially as we start getting into the family cabin. You know, it's interesting to always talk about some of your own situations and what can happen with the family cabin, and we'll kind of discuss some as well as we go through here of situations that we've seen.
Thanks, Pam. So this is one of my favorite topics, because it's one of the situations where there's a few right answers and many, 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 many wrong answers. The family cabin is sort of that perfect storm of a property with a significant amount of value, high sentimental value, and the issue where multiple people have a claim. So many clients do like to pass on their family cottage or their family cabin, because they want to keep it in the family and keep the good times and have it as a meeting place going forward. And, you know, while this is a noble intention, it often causes issues. It's one of the main sources of issues, whether it's within a testamentary trust, or it's in an inter vivos trust, or it's in a specific gift within a will. You know, and a lot of the issues that pop up on these things are things that people don't necessarily think of until they're faced with this problem. A good example, I've had a few clients in the past who thought they were being smart by putting their cabin into a corporation, having the corporation, because, hey, corporation doesn't have to deal with probate. Corporation doesn't have to deal with land transfer because it's held in the name of the corporation. But the corporation is just giving out use of its property for free to all of its family and friends. Well, somebody has a benefit to that ability to use the corporation's cabin. And so CRA will call that a shareholder benefit, and will consider that as an addition to income, taxable income for the year. And that can add up to be fairly substantial. Change of control and change of ownership on these things can trigger provincial and federal taxes. So we want to be careful on how they're held after death. The other one that we see an awful lot of from people say, well, I don't want to bother with probate and I don't want to bother with a trust. I'm just going to put my kids on title with me because what could possibly go wrong? An awful lot. So if we try to bypass probate, there's a presumption under common law that where a child, an adult child of the other holder, is on title with no beneficial ownership, or no clear beneficial ownership, that's the presumption under law, is they have no beneficial ownership and they're there as their trustee for the benefit of the other joint tenant. And this is where the beneficiaries under a will or beneficiaries under intestacy, if there is no will, say, hey, you're just holding that for us. And this can cause a lot of issues. And I worked on litigations where this has cost an awful lot of money. And it was generated because somebody did something on the cheap. Another issue with joint tenancy is beyond, the bypassing probate to having the presumption of common law, is the issue of what happens with that other joint tenant. So if I'm a creditor and I do a property search and I find this property with this person's name on it, I'm going to lien that property. And now the burden is on the other side to prove, well, I don't actually own this, I own it from dad. Well, good to know for those other people waiting in the wings to receive it as beneficiaries of the estate. Or conversely, now that property may have a for sale order because the other joint tenant has a creditor. This could also be a spouse as creditor. This could be somebody running a business who runs into problems and they have their name on this title. So adding somebody to title can be a real risk if you're not careful. And it's one of those ones that it resolves itself in a lot of cases enough that people think it's safe, but there's a lot of risk in just adding a child to joint tenancy. And another thing that I don't have on here, but comes up an awful lot, is a disposition. CRA will exempt a principal residence, and in a lot of cases for retired persons, the family cabin is their primary principal residence, and so for them, there's no capital gain. But for that other child who's on title, well, that's not their principal residence, and so now when that passes on, there is a disposition event and there is a taxable event. And historically, this one kind of, avoided CRA's detection because we didn't always have to report principal residence dispositions, but now we do. And CRA is getting a little bit wiser to there being joint tenants and who actually holds ownership rights, and they'll presume and they'll reassess on a lot of these bases, and then the burden is to prove that you didn't own 50%.
And I think the common one here too is, like when people haven't put it into a trust, you see the joint tenancy. You mentioned, a few times about joint tenancy, or, a lot of times we've figured out people have actually registered it tenants in common, but then didn't leave it to the other people who owned, left it to their estate. And then all of a sudden those other people are like, well, I hate those kids. Those kids take advantage of everything and they do this and they do that. And then World War starts after that, where we've seen, and that's going to be on our next slide, but World War starts where it's like, well, no, the kids are coming down, every weekend and everything, they're messing up the place. And then, people sit and cry all weekend because it's like they go up there and they end up spending 4 days, 5 days cleaning the mess that those kids made. So, the ownership of the cabin becomes really important. Is it joint? Is it joint with each other? Have you, done a trust properly? Have you actually put it into a trust properly? Or are you just trying to, go about it where, hey, we all own jointly and that's going to work out? Because that never works out in a will, and you've got to make sure that the will's congruent with what you're doing as well, which many people haven't considered. They'll just say, well, the cottage goes to this person, or this property goes here, and that's like they haven't even thought about the ownership of it or given the lawyer their deeds to their property, the title.
No, and that's a really good point. And a lot of times when we're doing estate planning, we do go and pull the titles on everything. But at the same time, we can only pull title on what we've been advised to own. And I think a really good point that you also brought up in your comments is tenancy in common. And a lot of times people will do that because instead of joint tenancy, because They go, well, hey, all of my kids hold an equal interest, but it's separate, so you don't have to worry about right of survivorship. Well, you still have the same issues of creditor disputes, except now they're going to seize on a separated interest. They may still be able to force a sale of the property to get that interest out. Or you have the other issue of what third party is going to want to buy a piece of a property that's held by a couple of siblings. It's going to be practically worthless. So you can run into a lot of situations where all the children don't want to sell. You have a bit of a problem, and it creates a lot of acrimony, and it can create a lot of issues. So what do we think of from there? Everything we possibly can. When a cabin or cottage is part of an estate plan, whether under a will or in a trust, testamentary or inter vivos, we should always be asking at least these questions, which is, how many beneficiaries do we have? Are there beneficiaries that are minors, or could there be minor beneficiaries? So if we have a situation where we're leaving it to all the kids, but if one of the kids die, do their kids get to step into their place? Is it a blended family? Does everybody get along? No, really, do they actually get along? And would they get along if they have a shared property, which in some cases may be one of the largest, if not the largest, assets that they own? And then from there, we have to think about what happens if one or more of these people die or become incapacitated. One that comes up an awful lot is, what about the income disparity between the beneficiaries? If you have 3 children and one of them has a combined family income of 500,000 a year, and another one has 50, and another one is, around 150. Well, how are they going to all react to capital improvements? How are they going to react to expansions and cleanup, and maybe hiring the maid service versus everybody having to bring a mop and a dustpan? These are things that cause huge fights, because all of a sudden it's, well, you can afford to do all these things, so you should just do it because mom and dad want that. Well, mom and dad probably didn't think of that. But that, becomes the beginnings of a long and acrimonious and miserable relationship, all because of what was supposed to be left as a fun leisure property. And so from there, ignoring the income disparity, saying, let's say everybody has the same amount of money. Where does it come from to pay taxes, fees, maintenance, capital expenses? Is it going to come out of the trust? What happens when that trust runs out of money? How will use of the property be allocated? Pam and I talk about this one a lot, because who gets the good long weekends? Who gets during the week? And if somebody can take during the week, well, lucky them. The rest of us have to work. Well, that shouldn't be offset. ... How do we have a predictable formula for that? When can the property be sold? On what terms? One of the things I do whenever I'm in a position where I can't talk clients out of just letting the family cabin be sold is I always install a chicken switch for the trustee, which is, if the trustees had enough bickering, if money's running low, if people aren't using it enough, they, in their full, absolute, unfettered, as many of those types of words that I can think of, discretion, can sell the property, distribute the net proceeds, and that's that. But that's not always how it works. It's not always what people want to do. In a lot of cases, that's not in there. And where the trustee is one of the kids, there can be a lot of emotional and mental issues relating to that. Do they really want to be the one to pull the trigger on mom and dad's cabin? Do they want to be the hated sibling? So sometimes in those cases, I'll try to bring in a special trustee, which is a third party. It might be the family accountant. It might be a trust company, or somebody completely dispassionate. I try to make sure it's not me, but if I get backed into a corner. But effectively, that's some of the things you have to consider each and every time. And as you notice, when we talk about property allocation schedules and professional trustees and ongoing maintenance and capital expenses, this can become a very, very costly endeavor. I had clients one time that we set up essentially a partnership to hold the family cabin and lake property. And let me tell you, that partnership agreement was $20,000 worth of time. It was incredibly complicated. It was about 50 pages long. I mean, the property justified it. It was worth several $1,000,000, but at the same time, that was just to get it set up. Now we have to deal with all the ongoing maintenance. So it can be a very, very costly endeavor to do it properly, or we risk, things going south, and litigation can be an incredibly costly endeavor, all for something that's supposed to be fun. So ultimately, in a lot of cases, it's just prudent to allow the property to be sold and the proceeds divided up. Enjoy the time while you can. Maybe you sell the cabin during your life, or your executor sells it when you pass away, because what you may end up being gifting is a damaging burden, a costly burden, an albatross around somebody's neck. But of course, if you're going to do it, if you are going to pass on a cabin, a trust is one of the best ways to do it if the time and effort is taken to structure it properly. But that time and effort may involve family meetings. It may involve multiple professionals. It may involve bringing in a professional trustee. So if we do it right, there is going to be a dollar sign attached to it. And I think knowing that going forward helps you decide, really what you want to consider for the family cabin.
Exactly. So of course, when we come down to any kind of trust planning, obviously the big thing that we look at is obviously tacking some insurance onto a lot of the planning. Not only is insurance a great way to actually plan for the trusts, even on deemed dispositions and estate freezes, it becomes a great way of equalizing out the estate. Any kind of tax exempt insurance also allows the assets to grow tax sheltered and diversify the assets out. So if you only have certain business assets, you may want to actually diversify that out to have more cash value inside of it. And on the 21-year rule, a lot of people kind of go, well, what then? What do I do then? Who pays the tax? Who pays for all this kind of stuff? Well, that tax exempt insurance policy should pay for all of it. That's how we design it, so that it does pay out that tax and it's growing along with the tax. And then insurance can deal with any kind of tax liabilities within the trust on the way out, as well as at the 21-year rule. So it kind of allows for a complete estate equalization, and also allows to be in the trust. It allows it also to be there for the beneficiaries should they need it as well. And it allows some cash value should you need money along the way as well. So, you kind of get the best of both worlds, and we make sure that that covers everything inside that trust. Since again, it's like an individual and we want it to be covered for everything, just like we would want you to be covered on all of it. So just solidifies the trust planning all the way along. So now we come down to questions. Do we have any questions, Jeff?
Hey, everyone. Yeah, we do have a question here. It comes from Justin. He's asking, what are the administration costs associated with setting up a trust?
Great question.
So that's going to depend on the type of trust we're setting up, the type of trustees, the duration, but generally a family trust, if it's done properly, will start at about $5,000 if it's an inter vivos trust, and it can get a bit costly from there depending on the complexity. If it's an alter ego, joint spousal, those types of things, depending on how much tax planning is going on along there, then there's going to be a fee for the tax planning as well. But that's generally where we're starting on that. A good, well thought out testamentary trust within a will will add at least several hours worth of time to a will, because a testamentary trust is public, because a testamentary trust tends to be a lot more fixed with no discretion. You have to take the time to do it right the more complex it gets, and so that can be a real cost driver to estate planning, but a worthy one in the right situation. You want to have a drafter that knows what a qualified disability trust is and knows what section of the Tax Act to go to figure out if it's in compliance. Same with spousal trusts and whatnot. So there is a bit of a cost attached to those. Now, the trustee is a bit of a random one. It can be anywhere from somebody agreeing to do it out of the goodness of their heart and the repayment of any expenses to several $1,000s a year. Trust companies will typically charge based on a percentage of the value of the trust. as an initial cost, and then typically an annual fee will be based on capital receipts or receipts from proceeds of capital, so essentially from the income of the trust. And some will agree to do it as a fixed rate. I know some of the lawyers that I used to work with, like Dennis Nerlin, would charge a flat rate per year depending on the trust. When I'm acting as a trustee on a trust, it tends to range between $3,500 to $10,000 a year, or an hourly rate, depending on the nature of the services required as trustee. If it's a relatively straightforward trust where we're reviewing financials and taking care of beneficial distributions on an annual basis, it might be on the lower end. If we're having to have monthly meetings, family meetings, we've got potentially contentious beneficiaries, then you're looking at a higher amount. And then from there, there is an annual compliance. So you do have to file a T3 with CRA every year that the trust is in existence. Technically, even if there's no activity in the trust, though, historically we used to get away with a letter to CRA saying, hey, no activity, but CRA likes to see T3s. T3s are not something I'd recommend you go to H&R Block for. These are a little bit more nuanced returns that you want to have a good tax accountant working on. And so they're usually about $1,500 to $2,000 a year. And then those are your standard administration costs, but you may have valuators, you may have financial analysts, family coaches, whatnot, that the trust may take on as an expense. So in a lot of ways, you do have to pay to play a little bit on trusts. And so I generally recommend trusts have a minimum of $500,000 in assets, unless we have pressing requirements that necessitate a trust, like a disabled person or a spendthrift person. Or if we're dealing with more simple minors, trusts and wills, then the amount is much less, because we need to have some sort of trusteeship in place for minors. Otherwise, the public trustee takes it on, and we don't want that. So it largely depends. A properly structured trust with a sufficient amount of capital in place, based on its income growth alone, will cover all of these costs, and then some, and it should still be growing.
Thanks, Matt. Next question comes from Dawn. Do you need a lot of financial knowledge and know how to be using trusts, or just have a good team in place?
I'd like to say a bit of both, really, because we try to educate you on trust and how it actually works for you, because you definitely want to come into it with some knowledge of what a trust is. And of course, we educate people. So for all of our clients that come in, we usually say, this is where a trust could really benefit you, or it might be a change of ownership or a change of property or a change of something that we kind of say might be more beneficial. Or, maybe it just doesn't apply yet, and we have to be planning for it the next 4 to 5 years, and then we start setting things up so that it actually is planned for ahead of time. So I don't think you need to know all the nuances of trust. I don't think you need to know all the tax rules of trust or anything else of the operation of trust, because of course, Matt and I and a lot of the accountants that we work with keep pretty solid on all the new tax rules and all the new rulings that the government's coming out with, which, the last couple of years has seemed almost endless on all these things. So we try to keep up with all of this type of stuff, and we try to bring it up to people that we feel that it might be more applicable, especially when people did their wills many years back, and all of a sudden they have a disabled child, or all of a sudden something happens in the family that they go, wow, okay, this might be a little bit more beneficial. And as you build up assets, it often becomes very beneficial. So then we'll bring it up to those people and say, this is what it looks like, this is what we should be doing, this is how it fits your planning. And then we talk about educating you on that, that's specifically pertinent to your situation.
Yeah, that's exactly it. There's no need to go rush out and get an MBA or a master's in tax to deal with trust. At the same time, there does need to be a willingness to learn a basic understanding of trust, especially if you're going to be a trustee. If you're going to be a trustee on a trust, there is a fiduciary duty. So you do want to be mindful of that. But even if you have a fiduciary duty, it's not a fiduciary duty to be an expert in all things tax, trusts, finances, accounting. it's a duty to have care and control and take reasonable, well thought out decisions. And that can be done by taking on expert advice. If you're going to go into trust planning, you don't want to be an absentee trustee, and you don't want to be an uninformed client, but at the same time, we do have experts around it. If you're making the foray into trust, you should have those experts behind you.
Great. Our next question comes from Gabe. He's asking, can you have a settlor change over time? For example, wanting to have one of your children to be a settlor for their disabled sibling, but you want to wait until they are older and more mature to handle being a settlor.
So no, because you would be essentially creating new trusts, or you would have a settlor and then a subsequent contributor. And then again, that could be a deemed resettlement of a trust. So a settlor provides the initial capital of the trust, and then the settlor effectively steps away. Sometimes a settlor is also a trustee, but we have to be really careful when we do that, because if a settlor still exercises control, then attribution applies and the taxes go back to the settlor, defeating a lot of the purposes of the trust. Now, if the question was sort of relating to a trustee, that's a completely different story. So trustees can absolutely change over time, but there may be prohibitions in the trust deed on who exactly can be a trustee. So sometimes we'll design it so that the children can never be trustees, or the spouse can never be trustees, or the settlor can never be a trustee. Or we may have a provision, and I like to use this one every now and then, where we have an independent class of trustee, where they have to be a lawyer who does tax or trusts and has at least 5 years of experience, or maybe even more. They have to be a CPA or a CA before the CPA change, but they have to be a tax accountant. They have to have that experience in tax, because you don't want an audit accountant necessarily, or a trust company. So in that situation, we can change it. We have to be sometimes careful when trusts are being drafted, not to have too much ability to vary every single term, but we also need to be able to vary a lot of things over time, because things change. So another thing to bear in mind, because there's a lot to bear in mind when it comes to the fun world of trusts, we may have a provision that appoints successor trustees. We may have them already lined up to say, if this person can't act anymore, this person gets appointed. When this person reaches a certain age, they get appointed, or the trustees are invited to appoint them. Or we may have a person entitled to appoint, or a protector, they're sometimes called, but protectors are ever so slightly different, so we're careful about the distinction. And that person who's entitled to appoint may have that discretion. When we're dealing with a situation where we set up a trust and the children are young, but we anticipate this trust surviving until they're old enough, we may build in that recommendation that they become trustees over time in the deed. We may do that in a letter of wishes, or we may never want them to be trustees of that particular trust, because the idea of that trust may be to only last 20 years and then be wound up. And at that point in time, the kids just may be in their early mid-20s, and it may not make sense. One cautionary note: when you do a letter of wishes, it's not binding on your trustees. So if the goal is to have your children as trustees one day, especially let's say they're adult children now, or they're teens, but when they hit 30 or 35, you want them to be trustees, don't appoint a trustee who's in it for themselves. I've worked on a few files in the past where the trustees of the trust are actively ignoring the letter of wishes because they don't like the kids, and they don't like the idea that if the kids are trustees, they may lose their day jobs. So you want to be careful on that. If you want it to be a direction on the trustees, it's got to be in the trust, or you appoint somebody like a professional who really has no vested interest other than to see your trust work out, because A, they're professionals, it's their job. B, a job well done is the audition for the next job. And C, it's what you want.
Okay, great. Next question comes from Marge. When multiple beneficiaries are involved and fair versus equal issues may exist, does life insurance help sort things out? And do you coordinate group meetings to plan those types of things in advance?
Yes, so definitely, even how we've talked in other sessions, we've actually, from the first session, even with the Willing Wisdom Index with Tom Deans, we have a lot of family meetings with people to sort out those kind of issues. And especially if there's quite a few children involved, you always want to make sure, and I always say this to people, is equalization of the estate. Because as people get older or they deal with certain issues, you get this, well, they got this, well, they got that. And unless you're discussing it ahead of time and kind of saying, this is why I'm doing what I'm doing, or this is what my cause is, we often try to go in initially and say, how can we equalize this for everybody? And if there's a reason why you're not equalizing it, because let's say someone's got a great job, they're successful in their own rights, and you may not want those assets to go to those people just because you don't want to, and you might choose somebody else, you might choose their children. And then it's like, okay, how do we make sure that everybody feels just? Because that's the biggest thing in any kind of estate planning is someone going to feel out of sorts or pissed off that it hasn't happened the way they wanted it to happen? Because that often is where it starts with estate litigation. It's just emotion. It's just pure emotion where somebody's like, I don't agree with this. This is what's happening. And that's where people then hire the lawyers. So it's like, if we have those conversations ahead of time, we put some insurance in place, because it's really easy and fairly cheap if you do it, early enough. We were talking about that earlier, is age becomes a big factor. A lot of people really start considering this in their 60s and 70s, or even 80s, where insurance starts to become expensive and if not impossible sometimes. So that's where you have to determine whether or not the cost, can really equalize it. But if you do this planning early on, and a lot of our clients are, mid 40s to early 50s, and you can get some really great planning and some really great insurance cash value planning to equalize the estate in there for sure.
I think that's exactly it. And I think family understanding early in the process can be really helpful, because often equal isn't fair and fair isn't equal, especially if we're looking at a situation where one of the children's getting the private corporation shares and they're taking over mom and dad's company, and the other kids are getting cash. Well, cash is king in a lot of ways, and there's no risk behind the cash. It's okay, I'm going to get $1 million. Awesome. I may get private corporation shares that are valued at $2 million, but what if that company gets sued or runs into problems, or the government won't build pipelines to Tidewater? And that's what I do. I'm a service company. I got a lot of risk. And that $2 million gift may be worth nothing. So what would be fair? Would it be fair to give those other children who got cash more? Maybe, maybe not. And that's the best person to judge that is you, as the parent, as the testator. You know your family, you know what's right and what's fair. And sometimes, what's right and what's fair isn't necessarily, well, these people are doing better. That may not matter. That may not be fair either. And so that's where everybody's mileage kind of varies, and insurance can certainly help even that out. And it could even be, if you have a trust set up, a wait and see approach where we distribute out the estate and we wait and see. And if all of a sudden those private corporation shares tank, well, the trust may distribute the insurance proceeds that it's been holding disproportionately to the child who had the company that failed because of whatever reason. And maybe if it failed because of their incompetence, they may not. But if it failed because mom and dad really were the company and the clients just didn't want to work with the kid, maybe we equalize, maybe we don't, and we can have that option. But the best way to have that option is to have the discussion while you're around, so that the kids understand how it's going to work, and the trustees know how their discretion would be exercised, or how it should be, so it's more defensible down the line.
Thanks, Matt. Thanks, Pam. Next question comes from Jay. He's asking, how do I know if I should set up a trust? When and how does it apply to me? Will you guide me?
So Jay, if I can mention, Jay's one of the people who has a BC property. So, BC property and taxes currently are becoming a great issue. So, this has been changing. So, for the past year, for sure. Um, Depending on the ownership of the BC property and what you guys decide to do with the ownership of the BC property, I think that's a real criteria where you start looking at whether or not a trust or even the value of, like Matt was talking about earlier, the value of a professional corporation starts getting far beyond, your capital gains rate, where it's like, okay, we may want to do some planning around that. That's where all of a sudden it really becomes a key point in what we're doing or how we're doing it. Or there may be also like benefits of having a spousal trust or certain issues where it's like, well, I want maybe the property to go to the kids later on. And that was my whole key role is, are we having it for a retirement property or are we having it for the kids? And that's two very separate conversations as well. So I think, there definitely is the aspect of a trust, and definitely we will bring that up as it becomes pertinent here, as it is going to become more pertinent for sure. And then we usually sit down with Matt, we come up with a whole scenario of looking at, where are we at? What are we going to do? What's the future plans? How does that fit into the retirement plan? Is this for the kids? And we structure a plan around that. So definitely we are involved in doing that, and that if that's something that kind of interests you and you kind of say, this seems to make sense for me, then yeah, we start moving that direction and kind of looking at how it can benefit you.
That's exactly it. I mean, there's the easy analysis of, how long you plan to hold the property, and if the tax benefit of having it in a trust exceeds the cost of setting up and maintaining the trust, then it's a no-brainer from that point of view alone. But even if that math doesn't add up, there may be other reasons why it does add up. But really, it starts at looking at the property and what your goals are from a short, medium, and long term. If it's something that you plan to hold for a few years and then sell, it may not be worth setting up, administering, and winding down a trust within 3 years, because you may not even have that much of a capital gain. You may not die, so there's no probate issue there, and it may not be prudent. So, I mean, we look at the value of the property as well. Are we putting anything else in there? What are your plans? I mean, a big indicator that a trust may make sense is, you're approaching 65 and you want to retire in BC. Well, that Alberta trust would be pretty good to hold property, to hold private corporation shares. And that, might make sense to set up, but your mileage will vary a lot depending on that. And I think Pam and the team are a good place to start for that.
Thanks, Matt. Thanks, Pam. Well, that's all the questions that we have right now. If any questions come up after the webinar, feel free to email us at info@thetowergroup.ca. And thanks everyone for joining. And Pam, I'll leave you with the last words.
Yes, thanks everybody for making the time today. We really appreciate you coming out to listen to us, and we look forward to, if you want to review it at any time. Of course, we are going to do a replay of this as well, like we do of all of them, as well as we'll have it up on our YouTube page, and Matt will have it up on his YouTube page on Field Law as well. So thanks again, and thanks again, Matt, for all your informative advice. You're always so amazing, and just this great source of knowledge, more than anyone I know. So we always appreciate having you.
Well, thank you for having me.
Thanks again, everybody. Hope you have a great day.